standing orders regarding parental access. The court enters the following temporary orders and finds said orders to be fair, reasonable, and in the best interest of the minor child. 1, the defendant shall return the minor child to the mother plaintiff on Saturday, August 29th at 12 o'clock p.m. at Vernon Police Department. 2, the matters continued to Monday, August 31st at 12 for compliance. This was an excusable date. 3, the defendant may have parenting time as agreed to by the plaintiff mother. 4, defendant shall have reasonable daily parenting time via video chat and phone calls with the minor child. 5, the court finds that there is an urgent need to appoint the guardian ad litem and that it is in the best interest of the minor child to do so. The court appoints the Children's Law Center as GAL. 6, the court accepts the plaintiff's number 9 proposed order regarding identifying a proposed counselor for the minor child. 7, the party shall exchange financial affidavits within 15 days. 8, party shall report back to the court in 21 days to address GAL's duties and fees/retaining fees. On August 31st, the court entered the following order. The matters continued to Wednesday, September 2nd at 2 o'clock p.m. for the parties to appear in person and the defendant to show cause as to why he should not be found in contempt for violating the court's order entered on August 28, 2020. On September 2nd, 2020, the court entered the following order. The court called this case at 2 p.m. Defendant was not present in court. Therefore, the court ordered a capias on the defendant with a cash bond of $5,000, and the capias is stayed until 4 p.m. today. If Mr. Riley does appear with the minor child and exchanges her with the plaintiff by 4 p.m., then the capias is vacated. If the defendant does not appear, the stay is lifted. Then the court recalled the matter at 4 p.m. with the defendant present in the courthouse with the child. Therefore, the capias is vacated. The court orders a $5,000 bond, which is stayed pending the transfer of the custody to the plaintiff before 5 p.m. The bond is vacated if the defendant complies with the transfer of the child. The defendant is to transfer custody to the plaintiff immediately, wherein the plaintiff shall have physical and legal custody. The court order from August 28th remains in full force and effect. Plaintiff shall not use illicit substances while parenting the child, the plaintiff being Priscilla Perry, and Jacob Chandrar shall not be in the presence of the child. Apparently, Attorney Johnston was appointed, and that appointment was terminated. The court knows that subsequent to that, on August 31st, the court appointed the guardian ad litem Children's Law Center under the indicating an emergency situation. On September 15th, the father, Timothy Riley, filed an ex parte motion number 127, alleging that the child is not in her mother's custody, that the mother has taken her phone from her and erased his phone numbers. He alleges the child's been victimized and abused in the mother's care. He indicates that the mother has attempted to deceive the court, is not a mentally fit person, and that she has an addiction problem and is isolating the child from her family. He is being denied access, and the child is being denied access to her father, a phone, and a better education, and the child is not being properly cared for. That motion on the papers was denied by Judge Maczarowski and was set for a hearing today. Additionally, on that same date, September 15th, the father filed a motion for contempt number 128, alleging that he's been denied access to his daughter in violation of Judge Maczarowski's order that he have daily contact with the daughter. That motion was also set for a hearing today. So I think that takes us up to where we are. Did I accurately and correctly reflect where the record or the court proceedings for the parties and for counsel?
Your Honor, if I may, I would note that during the hearing of August 28th, 2020, there were 3 orders that I didn't hear Your Honor recite. One is that the defendant was found in contempt at that time. 2 is that my client was granted sole physical and legal custody at that time. And 3, my condentulati child support motion was continued until today. And
Your Honor, I gotta object to that statement.
Okay, sir, I'm going to hear from you a second, but let him finish, and then I'll give you an opportunity to respond. So that he was found in contempt, that your client had sole legal and physical custody, and the PL child support motion was to continue to today.
Correct, and I actually, Your Honor, I'm not asking that anything be done today. I obtained a transcript of the proceedings, which confirms everything I just said. And I'm happy to submit that to Mr. Riley and to the clerk of the court if that would be helpful. I'm just trying to make sure the record is clear.
Okay, so I'll hear you in just a second. But what you're asking is submit a transcript of what happened that day to ensure the clerk's orders line up with Judge Maczarowski's orders.
That's it, yes.
Okay. Mr. Riley, what do you want to say on that, sir?
Well, I have a different understanding on the contempt, the notion that I was found in contempt because the capias and everything that was held over my head for that contempt was dropped in the middle of the proceeding.
Vacated.
Yeah, it was vacated. So
what I'm going to do is, Attorney Potter, if you do have a transcript, please submit it to the court. Make sure Mr. Riley has a copy. And I will take a look at that and the clerk's rendition of the order and make sure that they are in alignment.
I will do that, Your Honor. And the only other thing I need to add with respect to Your Honor's recitation is that I did not receive a copy of the motions that were filed by Mr. Riley. The family relations officer indicated that there were those motions filed. So I've since printed them and reviewed them. I see that the ex parte motion was denied, but to the extent there was an order scheduling those for today, I was unaware of that. And in fact, the invitation that I received for this remote case date, which was issued, I believe, 3 days after he filed those motions, indicates that it's the GAL report back. I have no problem having a hearing on those motions. But I would like a little time to prepare, and I would submit to the court that a hearing on those motions is going to take 2 to 3 hours, not a half hour.
Okay. So, sir, it looks like you did file the application and the court set it down for a hearing. And then if you are representing yourself, it's your responsibility for the motion for contempt and for the ex parte order to then have them served on the plaintiff.
I did serve those. I had those notices served. I did not do it with the state marshal, but the notices were served in her.
How were they served, sir?
Through digital notification. They were sent electronically.
You sent them an email with them?
Yeah, actually, I had two parties. I sent them off, and my mother sent them off to confirm that the plaintiff received them, and I also sent copies of the motions and all of the evidence to be heard last Friday to the plaintiff's attorney and his offices.
Okay.
I can acknowledge, Your Honor, that Mr. Riley did send my office an email Friday at 6:30 p.m. And I don't dispute that. I'm just saying that in order to properly defend those motions, I need a little more notice than that.
All right. So let's figure out.
I given the nature of the evidence in the emergency ex parte and the imminent danger that the juvenile is in, I would have to encourage the court to begin the proceedings on this stuff today so that the most important elements of this information are heard, as they do prove that the plaintiff has lied under oath, deceived the court, given the court a fake name. There's a fake name on one of our court orders right now. And there's some very dangerous things happening in that house that need to be addressed immediately so that I can get my daughter out of there.
All right. I hear you, sir. Let me ask the guardian ad litem. Attorney Ryan, you are the guardian in this matter?
I am not, sir. There was a conflict with our appointment that the mother waived, but the father has not waived, and therefore we're not able to take this case because he has the right to not waive his conflict. Excuse me.
So from what I understand, it's vital that this court understand what's going on for your daughter. And the best way for us to understand that is to have a guardian talk to her, look at what's happening in both homes, talk to any collateral contacts, and make recommendations to the court based on that information and be subject to cross-examination to show that she accurately and diligently performed her duties. The Children's Law Center works based on a sliding scale, and I assume that when this appointment was made, what's the status of everybody's income and employment right now? I'll start with you, ma'am. Are you working?
I am currently laid off due to the COVID-19 pandemic at the end of June.
Okay. And sir, are you currently working?
I do work for a nonprofit, but I don't generate any income off of that for myself.
Okay, so you would qualify, based on what you're telling me, for a state-paid GAL. And the Children's Law Center takes a lot of those cases for this district. Can you ethically state what the nature of the conflict is? Was there prior communication?
Yes, the plaintiff does have a prior communication, and the conflict for me goes beyond that for a number of reasons that I won't go into detail about right now. But there is a conflict of interest there.
I need to understand what that conflict is if I can try and help you resolve it. Otherwise, we've got to find somebody to fill that role because the court wants to hear what your daughter has to say, and we need a guardian in this case.
I kind of wanted that to happen 3 weeks ago, and the GAL had an FTA, a failure to appear, and my daughter needed all this stuff 3 weeks ago. So to kind of nip it in the bud, I printed out a bunch of police reports and submitted documentation to be seen as evidence today. You can see it's been tagged, and this will give the court a really good idea of what's been going on in that house and the danger that my daughter is in right now. So,
I hear that, and I want to hear that, and I want to look at that evidence, sir, but I need to know what's the conflict in terms of the GAL.
just prior contacts and we'll say counsel, if you will, on the plaintiff's behalf. She's had prior communications with them regarding a number of other things. It's not clear to me what those things are, if I have an entire transcript of that. Or, I'm just not comfortable with the state representing my daughter. I think there's a better
she's not,
private
understand
entity.
something. Attorney Ryan is not the state. She is a member of what's called the Children's Law Center, which is a nonprofit organization that seeks to advocate for children in conflicted custody cases.
Okay, perhaps I'm ignorant. Call me ignorant. I don't
No,
know
I
enough
just want to
about
make sure.
I'd
Yep.
have to talk to them further, find out a little more from them, what I can, and then make a decision down the road. But as for right now, I think the most important and pressing issue is the health and well-being of my daughter. And I think we could focus on how things have been for her, just taking a look at some body cam footage and looking at some police reports here that are absolutely relevant to her day-to-day life.
I couldn't agree with you more, sir, but the question is, I need to fill this role, whether that be Attorney Ryan or somebody else, so that they can get up to speed and be prepared.
All right, well, let's just fill the role for the sake of logistics here. Let's give it to the GAL. I'll go ahead and waive any conflict at this time.
Okay.
If that helps expedite the process here, because I'm ultimately trying to, we need to get down to the business of what's going on with my daughter here.
Okay. So Attorney Ryan, you've got it on the record now that Mr. Riley is waiving any conflict with the Children's Law Center based on any prior communication by Ms. Perry.
Thank
Is there
you.
anything you want to put on the record?
Oh,
Yes,
sorry.
ma'am.
Just at some point, I'll need that in a signature. And if I'm free to stay, I'll stay and hear today's testimony. But otherwise, I'll be in touch with both parties to begin the process as soon as possible.
Excellent.
So I think that it's vital that the GAL hear what transpires during the remaining time that we have, so she's aware of the issues as raised by the party, so she can thoroughly investigate the same, rather than hearing them third hand or having to get a transcript or anything like that. So I am going to request that you stay. Let me ask you, Mr. Lorenzo, do you provide any additional service to this, or do you want to stay and see if there's going to be a referral made or anything?
I don't have a reason to stay, but I am going to be here in the building till 5, so, need be. It's
So
up to
I'll let you
Stay.
tend to your other matters. If we need you,
Okay.
we'll bring you back.
Wonderful. Thank you so much.
Okay.
Good luck, folks.
All
Thank
right.
you.
So the court will also note that on the memo that was submitted by the Family Relations for today's hearing, it says that, number one, it says other issue. The 828 appointment of the GAL, I think we've taken care of that. Then it's got September 2nd, 2020 contempt of court orders. I would assume that those were the ones filed by the mother. And then there's the September 15th motion for ex parte and motion for contempt. So the court's got those three matters sort of in its focus. And I understand, Attorney Potter, your indication that you are not prepared to go forward on that. But you've seen the motions, correct? Your mic is muted.
Sorry about that. Thank you, Your Honor. Yeah, I printed them after I was told by Mr. Lorenzo that they were on the court's docket for today because, again, I didn't get them when they were filed, and the invitation that I have from Your Honor for today clearly indicates that today is for a GAL report back. It not only doesn't mention the motions that were filed by Mr. Riley, but it also doesn't mention my motion for child support that was specifically continued to this day by Judge Maczarowski.
Okay, so I can tell that, with 20 minutes remaining in the court's day, we're not going to be able to cover all of this. Is it possible that we can start hearing it, knowing that we're going to have a continuation on this, and then we'll hopefully the GAL can get up to speed in between now and then, or at least provide some assistance to the court, and we'll see where we go. But if the father is alleging that the child's in serious physical harm or danger,
imminent danger right now. She's in immediate danger right now, and
then I think we need to at least hear the basis of that to determine if anything needs to change in the interim, given that the ex parte was filed and is docketed for today.
I, of course, am concerned about my client's due process rights because although it may have been docketed for today, nobody told me, number one. Number two, I have no objection to commencing the hearing, but not really having had a chance to review it. What I understand is that he filed a motion to modify, that he filed it on an ex parte basis, that the ex parte relief was denied, but that it was set down for today. So I presume that what we're talking about is an allegation that there's been a substantial change in circumstances since the sole custody order entered on the 28th. Is that accurate? Just so I know what we're talking about here.
So, as I indicated to you and Mr. Riley,
my concerns, these concerns that I have, this evidence was supposed to be heard during our last hearing, where I was, threatened with duress and had to surrender custody to my daughter. I was prepared for a remote case. It was never indicated that the case was going to be in person, and that's why I wasn't physically in the building at 2 o'clock. I had to make last-minute preparations to get down there. I had less than 24 hours to prepare all of this stuff. My preparations were made to do this remotely, so I did not have the hard copy forms or the ability to go ahead and properly submit with exhibit stickers and everything, that evidence at that time. So none of this evidence has been heard, and my daughter's life and safety has been jeopardized essentially by the violation of my right to due process in these courts with the assistance of the plaintiff's attorney here.
Okay. So, first up, sir, I'm going to ask you very succinctly to give me an offer of proof in terms of what you intend to show the court and what your evidence is going to show. Tell me what that evidence is. We're going to make sure that that evidence can come into evidence, assuming there's no legal objection. Make sure that Attorney Potter's got copies of it, because working in a remote setting, we've got to make sure everybody's aware of everything. So I want to use this time to sort of prep so that when we do have the hearing, and I'll work with my case flow to get a hearing expedited, hopefully this week if we can.
Like this week, tomorrow would be great.
Well, tomorrow, sir, they've already booked 9 other case dates. But we're going to do what we can to expedite. But I need to understand what's your offer of proof and what you intend to introduce to evidence. And then, Attorney Potter, I'll ask you if you have any, what you intend to, an offer of proof from your side and what evidence you intend to introduce, so that we at least can use this as sort of a trial management 15 minutes.
I did provide the clerk's office today via a Miss Peabody, Karen Peabody, who should have given you a list, Your Honor, of exhibits, things that I anticipated presenting today, alphabetized from A to P. There are separate pieces of evidence, perhaps one of the most important pieces to the contrary of the plaintiff's statements under oath about having a live-in boyfriend and how she's been living alone, how she's the primary caretaker.
Hold on one second, sir. Madam Clerk, do we have a list of exhibits?
Yes.
I'd like to draw your attention to A1.
Hold on one second. I'm going to get it from the clerk. We've got a plexiglass barrier between us. Attorney Potter, have you seen this?
I have seen the exhibit list, Your Honor, yes.
All right. So I'm going to go through this really quickly, and we'll indicate, is there objections, or what are we doing, and how are we getting this evidence to the court?
First one I would like to discuss is A1963.
A1963.
Seriously?
So what I was going to do, sir, and you got to help me if I can't understand it. I was going to go through them really quick. You indicate you've got a Vernon something body cam footage.
Yes, sir. Vernon Police Department body cam
Oh,
footage
police
of a
department.
domestic case involved with my daughter and her mother at their home.
Okay. And you have the film of that?
Yeah, oh yeah, absolutely.
Okay. Attorney Potter, have you seen that?
No, Your Honor.
All right.
It's not attached to the
It basically shows all the violence and abuse in the house.
I understand that, and but the question is, to protect people's due process rights, Attorney Potter's entitled to see it before you introduce it to the court.
I understand that. I did give
how
him.
do you-
I did give him a copy of that late Friday afternoon. I think it was around tail end of 5 o'clock. Could have been 6:30, like he said. But I mean,
video
I don't
camera?
stop defending my daughter over the weekend. He had plenty of time to review this information.
But wait, I've got to understand. Has he seen the video footage?
I don't know. He's had time to see it. I don't know if he's taken the time to see it.
Your Honor, this is the package that I printed down from, that was sent to me by Mr. Riley at 6:30 on Friday evening, and it does not contain any kind of thumb drive or video.
There's an
that
open link to the video. All he had to do is click the link to watch the video, and the court has the video on DVD.
Okay. So the court has a DVD player, and what I understand Mr. Riley saying is he sent you a link that you can access through your computer, probably in the email, I would assume.
Yeah, yep. I sent it right to his attorney's office. I sent a copy of that same email that I sent to his attorney's office right to the court, and I also sent a copy of that email right to Priscilla to make sure that her attorney had plenty of time to see it.
All right. And Mr. Riley, so that the Guardian is up to speed, if you could forward a copy of that email to the Guardian, that way she can see the film footage you're talking about
I sure
as well.
will. Now, most important is Exhibit A1963, as this is going
So
to
I'm trying
completely
to find
discredit
it.
the plaintiff.
I can't see A1963.
It's on that CD. All these documents and their exhibit stickers are all scanned, photographed, and everything. You can read the document, pull up the document right off of the CD that your clerk just so kindly held up in front of the frame there. You have one CD containing the body cam footage and one CD containing digital copies of all of this material.
Okay.
Your
But I
Honor,
haven't heard yet if there's an objection from Attorney Potter before the court reviews it.
Well, what I was going to say, Your Honor, is that with respect to all of the written reports that I was provided with, I have no objection to any of those coming in. The only thing I don't think I've seen is the video.
Okay, so with the exception, you have no objection to F, which is the video, Vernon Police Department case report A1963.
All of
Sharing
these
it on
are
the screen.
referencing case reports, Your Honor, and I've reviewed everything that I was given, and I don't have any objection. I just haven't seen the video.
All right, so the only thing that you're missing in terms of seeing is the Vernon Police Department body cam footage.
I believe that to be correct.
Okay, so then the court will take into evidence its full exhibits B through P.
Well,
P is sort of a DVD containing all of the above.
but hold on a second, Your Honor, because the list that I was emailed only goes through N, as in Nancy.
Oh, I might have forgotten to provide updated. When I went to the court this afternoon, I did put in additional pictures and dates. We don't have to review that information now if he chooses to object, and I don't think we're going to have time anyway. And the letter P is just to...
It's a combination of everything.
Yeah, you got it. It's just letting you know it's all been
digitized,
consolidated and put in.
So what he's offering is, with the exception of the body cam footage, Attorney Potter, he's indicating, or Attorney Potter, I understand you're saying B through N can come in as full exhibits and the court can consider the same.
Yes, and then I'm happy to review what appears to be A and O so that, those can be ruled on as well.
Okay. All right. So I am going to admit those into evidence, and the court will look at them probably before our next court date. What other evidence do you have, sir? The only thing, so right now we're outstanding is A has not been come in yet, that the body cam footage, and O, the pictures have
So
not
I
come
would
in.
like to turn everyone's attention to Exhibit A1963.
That's number F.
That is, yes, sir. That is F on the list.
Okay.
If I may,
All
I'd
right.
like to start reading in the with time,
Well,
being
hold on one second.
being urgent.
I'm going to take all this stuff. I am going to read it. This is what you intend to introduce in terms of evidence other than testimony, and you're going to testify, correct?
Yes, that is correct. This is for the
Do you have
emergency
any
ex
other
parte.
witnesses that you wish to have testify?
Yeah,
besides-
my wife, Rachel Ninteau, Ninteau.
Ninteau. Okay. And other than Ms. Ninteau and yourself, sir, is there anybody else?
There is, but I'm gonna just move on from the other two witnesses I have to present at this time. I've got to converse with them a little bit before.
All right. So knowing that we're not going to finish in 10 minutes, it may be possible that you may be able to call them. Attorney Potter, what evidence do you wish to present to the court, and what witnesses do you wish to call?
Well, Your Honor, I had submitted case date compliance pursuant to the standing orders of the court, but again,
I got
it
that
just-
somewhere.
it contemplated that today was just the GAL callback. So depending on when Your Honor is going to reconvene, I would simply like the opportunity to amend my compliance, knowing that we're dealing with what I think to be a motion to modify custody, a motion for contempt regarding contact, and what may or may not include my motion for child support.
All right.
And I'm happy to do that whenever Your Honor orders me to do it.
Well, let me ask you, Attorney Ryan, knowing that the conflict's been waived, that you're just going to need to get signatures acknowledging the waiver and authorization so that you can talk to school professionals, medical, whatever. How long do you think it would take you to get up to speed?
Generally, I prefer more, excuse me. I would prefer to have 4 weeks, but it seems like this is much more urgent than just a 4-week
It is
normal
a very urgent matter, ma'am.
time. I mean, as much time as the court can give me, I'll do the best I can. That's all I can offer.
Okay. Give me 1 second. If I set this for a week from today, next Monday,
Oh, no. Mm-mm.
Well, so,
I don't know. I guess it's fine.
I have currently a pretrial that day and a callback, but I can move those, so that would give us the whole day.
I'm on trial at 3 that afternoon, sir. So if it could be in the morning.
I would be glad to do that at 9:30.
I am available, Your Honor, and have no problem submitting a revised pretrial compliance prior to that date. And I can also review the two video exhibits, although I may need some assistance from Mr. Riley as to getting those in a form
I would love
that
to
can
help you,
access.
Mr. Potter. I almost reached out over the weekend.
All right. So I am
I'm
going
sure,
to
I'm sure we
continue
can
this
figure
hearing.
that out.
I'm going to continue this hearing until Monday, October 5th at 9:30. A new link will be set. I am going to review all the material other than the body cam footage and the picture dates prior to that hearing. At a minimum, Attorney Ryan, if you could at least maybe talk to the child, that would give us some insight. In the meantime, the court is going to reiterate that the current orders remain in full force and effect. Those orders require that Ms. Perry.
Can we update the order so that the gentleman's name is actually his real name? Because right now his name is fake and it doesn't apply to anybody.
What is the name you think, sir?
The name that she gave, Jacob Schuendorf, was a false name she actually gave to police once when he stole her car. His real name is Jacob Kilhenny. He's
Could
actually
you spell that, please?
Yeah, it's Jacob, Jacob
Yep.
Kilhenny, and she consciously gave this fake name under oath in the same manner of which she did
Well,
when she
we'll
filed the
deal
police
with that
report.
during the hearing, but Judge Macherowski, I think it was
So she's
Shoran
lying.
or
Everything
something.
she said is a lie. I've been saying this to you guys this whole time and been trying to present evidence. And today, again,
Sir,
I'm
I'm
not
trying
able
to
to
give you your
present any
opportunity
evidence,
to
and
do
my
it, and
daughter
I'm trying
remains
to
in danger.
respond. Okay, so
And she's smiling about it.
okay, so the other part of the order was, I believe, that Mr. Riley shall have a reasonable daily parenting time via video chat and phone call with the minor
She's
child.
been failing miserably at that. Failing
Well,
miserably.
we'll hear that, and that's part of your contempt, and that's what we'll take up on Monday. But understand the court's reiterating that that is the current order of the court. The court will enter an order. And Attorney Potter, if you could get us the transcript, we'll try and correct the prior order if there's a mistake. But I will include Jacob Kilhenny in the court's order that the child's not to have contact with him. Also, again,
He's been
court
in the
will
home.
reiterate-
He's been in the home with the child present, too.
Well, sir, we'll hear that evidence in a week. But right now, I'm going to enter an order that Mr. Kilhenny not be present. Yes, Attorney Potter.
Your Honor, can I, again, just for notice purposes, is the custody determination that the court is taking up on Monday a de novo determination, or are we talking about a modification of custody based on what has occurred since the prior court order?
So understand something. The court is going to look at and is always charged with acting what's in the best interest of the minor child. And if issues are raised during a hearing, even if not properly pled, the court can sua sponte raise them on their own and change it to effectuate an order that is in the child's best interest. So I'm going to give everybody a chance. I am going to look at everything that's been presented, and we'll have a chance to talk about that on Monday. And I'll enter the order just so we have a correct name, whether it's Jacob Shoran, as Judge Macherowski indicated, or Jacob Kilhenny, as Mr. Shandorf, or Jacob Kilkenny, that he's not to be in the presence of the child.
Thank you. And lastly, Your Honor, is it your intention also to take up my motion for child support? Because we were...
We'll deal with that as well. And Mr. Riley, I do need you to file a financial affidavit.
I think I already did that and gave it to the clerks.
It may not have made the system yet. When I was looking for today's hearing, I didn't see one. I saw one for the plaintiff, and as well as a child
I
support
filled one
guideline.
out. It should have been part of, well, maybe you don't get that because I filled out a waiver fee application.
It's a different form.
Okay. I thought
Okay.
maybe, okay.
There's a financial affidavit online that you got to fill out, and you got to e-file and sign type thing.
Okay. Now, would
Okay.
a motion for dismissal on my part, when we reconvene and the facts really come out and there's, everything is different, I'd like to file for a motion of dismissal of all of this so that my daughter and I could be left alone while mom addresses her issues.
So here's the situation. The initial action that started this, and we've got about 3 minutes left, is a custody application, which says we need to come up with a plan that's best for the child. Whether the allegations are dismissed, whether the court finds that they were fraudulent or incorrect, there's still going to be an underlying issue between mother and father relative to the child.
I understand
That's
that.
got to be decided.
But mom
So
and I
that
have had
custody
an amicable,
application
privately
will still
litigated.
stand.
Right, but I would like that privately litigated without the tentacles of the state, respectfully, if you will, being involved in my daughter's life. And being that I have been so successful in doing that throughout her entire life so far, it's the kind of thing I'm going to remain continuing to try to do. And I think
Well,
once the plaintiff gets in a better place, she's going to agree that's the best for Araya.
I don't know where this case is going to end up. I am glad that you want to be actively involved in your daughter's life. However, the court cannot pass custody determinations to private third parties like it can an arbitrator or something like that. That unfortunately is part of the legislative design, and you'll have to take that up with the legislature. But we're going to see where Monday takes us. Attorney Ryan, if you can at least try and talk to the child, and we'll at least hear a report on that. I will look at everything.
Your Honor, if I may, can I grab everybody's phone numbers right now, if I can take 10 seconds, just so I can do it the minute we hang up, like schedule the appointments, if you don't mind, sir?
Yeah.
So I will disconnect, and you guys can stay talking on this
Okay,
link.
thank you.
Okay? All right. The court will stand in recess.
Thank you, Your Honor.
Thank you. If Mr. Riley, if you want to give me your phone number first?
Yes, ma'am. I'll give you my number and my daughter's number.
Okay.
My number is 860.
Mm-hmm.
Mr. Potter, please take this down too. 823-8965. That's 860-823-8965. That's for me, Tim Riley.
And can I text you?
Yeah, absolutely.
Okay. And your daughter's cell?
Yeah, that's going to be 860
Mm-hmm.
718
Mm-hmm.
1865, and that's for Araya Riley, Araya. And you could probably, I'm going to tell you, if you just tell her that you know who I am, tell her you're my friend, tell her, use all the tricks under the sun to, really get her comfortable. She's been very uncomfortable during this whole thing. She's very scared. Between me, you, and I mean all of this respectfully, no offense to the plaintiff here, but she's very scared. She's not allowed to speak freely at home. She's very scared. It's going to take a little bit for you to get her to be comfortable. I think an in-person thing where you bring her some French fries and a milkshake or something would go a long way. You let her know that you're here to talk with her for her daddy, and you want to hear what she has to say. And under that kind of greeting and welcoming, she will be more inclined to speak a lot more truthfully.
Okay. I will do my best. I will call you in just a minute or text you to set up a time for me to come out to meet with you, okay?
Excellent. Thank you so much.
Mr. Riley, can you
Yes, sir.
send me those? Can you send me those two exhibits or send them to my assistant in a way that I can click on them and open them?
Yeah, I sure will, Mr. Potter. I'd like, if you got time
And
this
me
afternoon,
too.
give me a call, or early this evening. Yeah, ma'am, I'll give you everything I have and complete access to it. Mr. Potter, again, I was going to reach out over the weekend. I think it's important that you really know what's going on with your client here. So if you have time this afternoon, early evening, please feel free, give me a shout. If I don't answer right away, it's because I've got other things going on, but I will return your call immediately. And if I don't hear from you or something, I'll try it during the week relentlessly.
Wait.
Just try to send the videos in a way that I'm able to open them, and that way we don't have an evidence issue next Monday.
Yeah, right on.
All right.
Okay. And Mom, what's your number? Do you mind?
Not at all. 860-593-4628.
Is that a cell as well?
It is.
Okay, excellent. So I'm just gonna text you guys. Well, we can talk about it right now, but maybe I'll just text you privately to set up our meetings if that's all right.
Yeah,
That'd be
fantastic.
Sir,
Whatever's clever.
Mr. Riley, if you send me all that information, you have the email, but if you need it again, I'll text it to you, okay?
Yeah, please text me your email, and I'll get all that information over to you within the next 30 minutes. Same with you, Mr. Potter. You guys can expect an email from me within the next 30 minutes or so.
And
Thank
Attorney
you.
Potter, just the underlining stuff for us, we'll need a consent to communicate so I can speak to your client. I'm not sure if that was done yet or not.
I'm not either, but I'll look, and if it hasn't been, we'll get one over to you.
All right, perfect. Thank you so much.
Thank you, dear. Have a good day.
You too.
Thank
Bye.
you. Bye-bye.
Bye.
Mr. Potter, be well, be swell, sir.